And this is where the dispute gets interesting. On one side you have a former spouse saying, I'm responsible for half this mortgage, so I need timely access to the information that determines what I'm paying. On the other side there's a privacy concern. What exactly does that login expose? The important distinction here is between having enough information to fulfill a financial obligation and having unrestricted access to someone else's banking information.
Your Honor, good afternoon. I filed a motion for clarifying orders, and I was hoping that the court could help us out in resolving a singular issue that remains unresolved between the parties, even after we've announced a pretty comprehensive settlement agreement before you the last time we were before this court. As part of the settlement that's been agreed to by the parties, Judge, you will recall that this is an apartment that was going to be sold, or the dispute actually was ownership pursuant to the divorce decree. The parties through the settlement have agreed to sell that property and to split the proceeds 50-50 between my client and Ms. Neyla Guerra. But in the meantime, until we can get that property listed and sold, it is also agreed by the parties that my client and Ms. Neyla Guerra will pay the outstanding mortgage 50-50. And so when we got to the terms of preparing a settlement agreement, which has already been papered, just not signed, Judge, because of the following detail. My client wants to have electronic access to the PNC mortgage account so that he could see the running balance and any changes to the account. Currently, that PNC mortgage account is in the name of Mr. Ernesto Guerra. Now, going back historically, Judge, this particular access, electronic access, was available to my client up until 2021. In 2021, the respondents in this case, Ms. Guerra and or her father, changed access and denied access to my client. And this was about May 3rd, 2021, where my client received an email from, which was then BBVA, the predecessor to PNC, notifying that there was a change and he could no longer have access electronically. As a reflection of why this is important, Judge, just yesterday we received a hand delivery letter from Ms. Neyla Guerra that back in May, the bank advised Mr. Ernesto Guerra that there was going to be a change in the interest rate. So they would change, this is a adjusted rate. It was going to modify the monthly payment. And so this is the type of information that obviously if my client is contractually obliged to or obligated to pay, should know, not 2 or 3 months after the fact, but contemporaneously if this change is made. And that's why electronic access should be provided. The other reason is because just in the exchange of monthly statements that are hand delivered and checks that are delivered, it becomes cumbersome. And if I'm not there, my assistant's not at the office, it just delays the whole process of exchanging monthly statements and checks, which is what the other side proposes. I checked on my own account, Judge, because I have an account at PNC, and the only thing that Mr. Guerra would be able to do electronically would be to modify, just as Mr. Guerra did, the settings so that it would deny access to somebody else. And we're willing to stipulate before the court and even put my client under oath that he's not here to make any changes to deny them access, to modify those settings in any way. When you have an electronic access to the account, you don't have access to the owner's primary information, social security number, so on and so forth.
That distinction is about to become the centerpiece of the judge's questioning. Would you give someone account access if you were legally responsible for half the bill? Next voice now the other side makes a very different argument. Their position is basically, the settlement promised mortgage statements, not online banking access, and they're raising a legitimate question about scope. If multiple accounts are connected, could access to the mortgage accidentally expose private checking or banking information? But notice something important. The argument is also leaning heavily on the man's criminal history. Legally, that history doesn't automatically answer whether this particular financial access is appropriate. The judge needs facts about what the account actually reveals, and that is exactly what the court starts investigating next voice, and there it is, the fact that could completely change the judge's analysis. The court has now heard that the mortgage and personal banking accounts may be connected.
So the risk of an invasion of privacy is de minimis. The access is paramount just because my client is obviously responsible for 50% of that note until the property is sold. And that's why we're here. We're hoping the court can offer some clarifying orders and direct the parties to give my client electronic access such until that time that the condo is sold and the proceeds distributed pursuant to our agreement.
Ms. Alanya?
Thank you, Your Honor. In the settlement agreement that we read into the record of the court, we stated that Ms. Naila Guerra would send the former husband, Mr. Salcedo, monthly mortgage statements so that he would pay the 50% of the mortgage directly to the bank. He could easily do this by going online, scheduling in bill pay, the account number that's found on the statement, and make the monthly payments that way. Mr. Salcedo is a convicted criminal. He's been in prison, and my client is concerned about him having access to the father's bank information, mortgage information, account information. He doesn't need that information. He doesn't need that access, rather, especially based on his criminal past. And additionally, based on, we did not agree to that in the settlement agreement. We only agreed, or rather, the parties only agreed, that Ms. Naila Guerra would deliver Mr. Salcedo a statement with sufficient information to make the payment. She and her father are opposed to this request for access to PNC account any more than the 6 monthly statement. He can make the payment in a different way.
Anything else?
It violates my client, Mr. Guerra's privacy. And it does not need to happen, and it was not agreed to.
I wouldn't expect so, but I have to ask, would the AG's office like to be heard on anything in this case?
Thank you, Your Honor. No, I believe the child support case is set in the title in a different court, Your Honor.
All right, so let me ask you all some questions, and ostensibly, Mr. Tames and Ms. Alanya, you should have and arrive at the same answer to these questions. So ostensibly, this is the exact information that the court would receive if this were a contested hearing and the court would be presented this in evidence and testimony. Because let me ask you, Mr. Tames, because it's your motion, and then I'll ask Ms. Saldana to confirm your statement. But this should be a matter of fact. Mr. Tames, what type of account is this? The PNC account?
It's a mortgage account. It's not a personal checking or savings account. It's a straight up mortgage account. And by the way, Judge, if I can add, that's the only account that Mr. Guerra has at PNC.
That was my follow-up question. So as far as you know, or your client knows and understands, once the login information is entered, is any other information available to access other than this one type of account, to your knowledge?
Not to my knowledge, Your Honor.
Same question, Ms. Aldania. What type of account is this? And is it singular and exclusive, or does it involve several?
It is a mortgage account. As far as I know, that's the only account, but I have not confirmed with Mr. Guerra that it is the only account. That's number one and number two. And then as far as number three, I did receive from Mr. Tames it seemed that it was like a power of attorney sort of form where Mr. Salcedo had my client signed, would have had access to Social Security information and other information. That was a big concern, very big concern for my clients, which is another reason why we're opposed to this, or they're opposed to this. And so for Mr. Tames to come in, I know that he's a very good attorney, very forthcoming and honest. However, I have not seen any documentation showing that electronic access would be limited to what he says, which is just to make a payment, which again, he can make that payment.
That means this is no longer simply a disagreement over convenience. Now we're talking about the possibility of exposing unrelated financial information. And the judge isn't going to simply pick one lawyer's version and run with it. Watch what happens next. The court starts drilling down into who was actually on the account when access changed, and what the bank records can prove next. Voice and this is the practical problem the judge is trying to solve.
And in a different manner.
But Ms. Guerra, Mr. Guerra definitively should know the answer, right?
Yes.
Ms. Guerra, I'm not gonna place you under oath because this should be, I think everybody should be able to agree to these set of facts and circumstances and situation. Do you know if only the mortgage information is available accessing that account?
Yes, I do. Both accounts, both my father's mortgage and banking account are connected.
So
Which is why we're opposed to it. If he were to get access to the mortgage account, he would be able to view my dad's personal banking, checking information.
Is that not your understanding, Mr. Tames?
That is not my understanding, Judge.
And that was not your understanding either, Ms. Alania?
I was not aware, but it appears that that is what it is. That, and I can see that.
And then my second question, and I guess I'll start with Ms. Alania this time. The names on the account, what names are on the account?
As far as I know, it's Ernesto Guerra.
And the court heard from Mr. Tames that at some point, Mr. Salcedo was on the account. If that's true, capital I, capital F, I don't know if it is or isn't. If that's true, when was his name removed from the account?
I don't know if it was when he was put in jail, in prison. If that's the reason, if that's even true that he was ever on the account. I don't know.
No.
Do you know the answer, Mr. Tames?
Judge, and I can upload this to Caseline. I have an email that was sent to my client on May 3rd, 2021, where he's notified that there was a request that was received to change the alternate address and the BBA contact information. Thereafter, he had no access to.
I'm sorry, what was the date?
May 3rd, 2021.
And I've never
right,
seen
folks.
that email.
No, me neither.
All right, folks. So let's does anybody here know what? I mean, impossible to say what the housing market is going to do, but how much time would be reasonable and necessary, do you think, for this property to sell? A month, 2 months, 6 months?
So there was an offer. There was a suggested price from Miss Martha Wright, and she said that she was going to propose it to her investors. So I thought that maybe at that point it would have been available to be sold. It would have been. So I don't know investors, right? Her investors. However, it hasn't been proposed to her investors because the settlement agreement has not been signed due to this request.
Yeah, I don't think we know. So regardless of what Ms. Wright told us, we don't have any offers on the table. The apartment is in pretty bad shape. And so one of the concerns Ms. Wright had from the very beginning there was a lot of junk there, and it was not in a marketable state. So I really don't know.
All right, so let's do this, folks, and let me make a decision based on this information, and I'll assume that everybody here has been forthright. If information is forthcoming that isn't the case, come back and tell the court that is wrong. All right, so in order to effectuate your settlement agreement, there should be full disclosure. The question before the court is how to effectuate that full disclosure. And it sounds to the court, because Mr. Tames said, and I'll presume that everything that Mr. Tames and Ms. Eleni have told the court is true, at least that's their understanding, that Mr. Salcedo had electronic access, but at some point there was a change in interest rate, which changes his obligation, as well as Ms. Guerra's under their 50% split for their monthly mortgage, added to the fact that if Ms. Alenia is correct, or I think her statement to the court was that only statements are being provided. The information missing then is the change in everything else, the change in interest rate, the change in monthly payment. So let's do this. The court is going to order that all documents generated by or from the or associated with the account be provided to opposing counsel. I think 72 hours, 3 days should be sufficient. And then I'm going to designate kind of like if this were a request for production where you can go and inspect, I am going to.
A mortgage statement can tell you what is due, but it may not tell the whole story when interest rates, payment amounts, or other account documents change. The court's solution is not unlimited access. It's a controlled way to verify and share the relevant information. That protects privacy while making sure neither side is left in the dark about a debt they're both responsible for. And honestly, the judge's message here is pretty simple. Transparency works a lot better when everyone can actually verify the numbers next voice, and that's the ruling in a nutshell. Access to the necessary mortgage information, but not unrestricted access to private banking. The judge created deadlines, document disclosure, and a supervised inspection so the parties can verify exactly what is connected to the account.
To allow and order an inspection, an in-person inspection on August 21st, which means that just verify that everything is true and correct. In other words, verify that it is linked only to one account or whether there's more. That doesn't mean that Mr. Salcedo can go in and review. No, somebody will be there to log in the information without giving him that specific login information, but then just do a walkthrough, because the information that should be coming is not only the statements, but any documents associated therewith. For example, change in interest rate, change in addresses, change in payment information, all of those. And if it's like any other bank, there should be an inbox with information, and that should be allowable and accessible.
So I'm not sure I understand. I know that with, like, for example, IBC or even Wells Fargo, if there are several accounts connected, like mortgage, bank account, savings account, then once you have access to one, you have access to all. So I'm not sure I understand what the in-person inspection is referring to exactly.
So I'm allowing Mr. Salcedo or his lawyer probably to go to your office. You or either one of your clients can log in and just confirm what you're saying. And once it's confirmed, you can move on. Or it's not confirmed, and then you'll come back to court and ask for further relief.
Okay, thank you.
And if it's only one account and no others, then that in-person access should probably happen every fourth Friday, or the Friday after the statement is generated, whatever the case is. So I tell you what, since it's on August 21st, we'll come back. On September the 3rd for an orders or an entry of judgment, should you need it, or whatever clarifying orders you want. September the 3rd at 2 p.m. for entry of judgment.
Thank you.
Anything else on this case, Mr. Temes?
No, Your Honor.
Ms. Alania?
No, Your Honor.
Mr. Salcedo, do you have any questions?
No.
Ms. Guerra, do you have any questions?
No.
To be clear, this does not give Mr. Salcedo free and clear access to do whatever he wants. It's an in-person, but it's guided and directed by someone designated by Ms. Guerra. That could be her lawyer, that could be herself, that could be a paralegal or whatever, just to confirm that everything here is everything that was said in court is the case, is true. All right.
So if it's determined that, so if it's determined that it is true, because it is, both accounts are connected, what then? Would I be able to just continue providing the monthly statements, which has all the information he needs to make the payments?
See, and that's where I think, and I think that was the whole purpose of our hearing here, because and Ms. Alani said exactly what you said. It's not just the statements, it's anything associated with the account. For example, in this situation, there was a change in interest rate and thereby a change in his monthly obligation to pay. And that's what they're trying to figure out. So once they confirm that that is true and correct, everybody can move on.
So this letter, and that's the reason that I turned it in yesterday, because my dad, he doesn't go through his mail. He brought me a bunch of mail to go through to review, and we barely opened it 2 days ago. And this letter shows that the interest and his payments, they actually go down, and this will be the amount that will be due for the next 12 years. Now I'm assuming and hoping that this property sells within this next year.
For purposes of stability and clarity, it would appear to benefit both you, Mr. Guerra, your father, and Mr. Salcedo, because you can't control the United States Postal Service, and apparently you also can't control the quickness that you receive these documents. Rather than rely on all of that, there can be a one-month inspection of if this bank has an inbox with all of that same information. you just go and click and print or download and share that information without having to rely on something that gets stuck in the mail that isn't going to be, that you might have an obligation immediately, but it's not going to be received and reviewed by you till a month later. So I think this just provides stability, and I really genuinely hope that the property sells as soon as possible so that everyone can move beyond.
Open and transparency, Judge. I think let's verify, and that when he's obligated to pay half the note, I think that's only fair.
Well, I think the court has instituted sufficient safeguards to provide that information without disclosing any possible personal information. Mr. Tames, Ms. Alania, good to see you both. Ms. Guerra, I wish you and your father and Mr. Salcedo well.
Thank you.
Have a great day.
More importantly, this dispute shows why the details of a settlement matter, especially when one party is responsible for a recurring financial obligation. What do you think? Was the judge right to create a middle ground solution, or should one side have gotten exactly what they originally requested? Let me know in the comments, and if you enjoyed this courtroom breakdown, hit like, share the video, and subscribe for more.